Good afternoon and welcome to today's webinar on GDPR. My name is Katie Gordon and I am the knowledge lawyer for the commercial team here at Pennington's Manchester. I'm here with two of my colleagues, Joanne Vengadesan and Anna Frankham. Joanne and Anna are both partners and data protection specialists in the team and will be discussing the practical steps that organisations need to take ahead of the GDPR coming into effect on 25th of May. Just a couple of housekeeping points before we get started. As a participant, your microphone is muted and the only voices you will hear are those of the presenters. Following the presentations, there'll be a short Q&A session. You can ask your questions at any stage of the webinar by typing them into the control panel, and you'll find the control panel at the top right of your screen. Just click on the orange arrow, then open up the grey question tab below. This webinar will be recorded and will be available later on the Pennington Manchester website. So now, without further delay, I will hand over to today's presenters, Joanne and Anna. Over to you, Joanne.
Thank you very much, Katie, and thanks to you all for joining us today. As 25th of May is fast approaching, many of us are in the thick of it in terms of our GDPR presentations. So this session is designed to discuss some of the practical issues that we will face in implementing the steps for compliance. We're planning to look at a few specific things which we've listed on this slide here, which we find that many organizations are tackling right now, and we'll provide some further detail on each of them. So, for example, we will look at, in practice, how are you going to comply with something which is as wide-ranging as the accountability principle. Just to say that because we won't be looking at the overview of GDPR principles in this session, and we're assuming that there will be some familiarity with some GDPR requirements here, we've also attached a link to another webinar that has been already recorded and which is downloadable and that you can view and share at your convenience, which talks about some of the basic GDPR concepts. So these are some of the key steps that, together with those identified in the earlier slide, that you will be looking at taking now. Reviewing privacy policies, consent practices, really creating a plan for how to comply, reviewing policies such as on internal information handling and security. You may be considering or have already appointed a data protection officer. You'll be thinking about the records that you need to keep, and you'll be thinking about a training program. A lot of this feeds into the broader GDPR requirement of accountability, which is one of the changes to the current Data Protection Act. So under the GDPR, businesses need to demonstrate how they comply with the GDPR. And really, what this means is that you will need to have some method of showing your internal capture, sharing, and use of personal information. So that is one key practical thing that needs to be done. You'll have to decide as an organization how you plan to address this. Is it going to be through, through a giant spreadsheet that you within the business have used as part of a data mapping exercise, which you then are going to keep live and which you refresh as data protection as the capture and use of personal data may evolve within your business? Or are you looking at tools that are available from third-party providers to assist you with that data mapping and demonstration? One of the things that our regulator, the ICO, is very keen on is that organizations have the ability to show what data they are capturing, processing, and using. So this is certainly an action point to be taken. Now, we are also familiar with the fact that we're going to need to update our privacy policy and possibly implement some new policies within the business. And we will be looking in a bit more detail at some of these, and in particular how to draft them and how to make them reflect the GDPR principles. But I think one of the things that shouldn't go amiss is to make sure that your plan for GDPR compliance includes implementation of these policies. So you have to think about how are they communicated in a way which is accessible. So this is accessible to staff, accessible to customers. Are you just going to be uploading a new privacy policy? Are you going to be emailing it out? for employee information that you will be updating. How is this going to be rolled out? There will be a time frame associated with that. One of the things that we found useful is to encourage organizations to use their intranet as part of internal awareness raising. So, for example, sharing privacy by design ideas and practical steps to refresh and keep live within a business the thoughts about privacy compliance. And you might find it useful within your teams that are doing different things or performing different functions within the business and interacting with personal data in a different way. To have somebody within each of those types of teams who is perhaps like a privacy champion. So all of these kinds of features go towards how an organization treats data protection and information handling as a whole, which feeds into your privacy by design compliance. So one of the other things that's important is to make sure that those who handle personal data on your behalf are properly trained, and you will be likely looking at online training modules that can be rolled out for staff, or perhaps thinking about in-person workshops to increase the awareness of data protection issues, and having a rolling program for this, taking into account new joiners as well. So quite practical ways of making sure that the data protection issues, it's not 25th of May, it's not a deadline for compliance that can be forgotten once it's passed. You'll need to have something which shows that you keep in compliance on an ongoing basis. Some of the other requirements, appointment of a data protection officer, we will look at in a bit more detail later on. And there may well be codes of practice and certification schemes that become available. So I think these are some of the things that feed into the overall accountability compliance. Moving on to look at specifically privacy policies, I'm now going to hand over to Anna.
Thanks, Joanne. So this is one of the key things which businesses are looking at updating at the moment if they already have a privacy policy, or introducing if they don't have one. You may think, right, we have a privacy policy already, we've had one for some time, but what's required under the GDPR is a lot more detail. And so really those documents need to be reviewed at this stage. And the sort of information that you need to be checking that is included is listed here, including the purpose and legal basis for processing. And one change is that what's going to be required now is that the legal basis for each type of processing should be made clear. So I think in the past we've seen privacy policies which gave a kind of generic basis for the processing, but now if you're processing different data for different purposes, you need to identify the legal basis for each one, and it may be helpful to do that in a table if as I say, you have several types of data. It's necessary to spell out the data subject rights, and those have been enhanced in the GDPR, and we'll talk about them in a little bit more detail. But you need to tell the individuals what their rights are. So, for example, to access the data, but also some of the new rights such as portability and the right to be forgotten. If you're going to be sharing data, then you need to say who you're going to be sharing that with. Retention periods is a newish area which many privacy policies haven't covered so far, but should be covering going forwards. So that individuals know how long their data may be kept, and it's very likely that certain categories of data will be kept for different periods depending on what it is. So again, you need to give some level of detail about that, or if you can't say exactly how long you're going to be keeping the data for, then you need to give an indication of how you're going to decide that. If you carry out automated decision making in your organization, which not all organizations do, but some companies do in relation to candidates who apply for positions, or for example in the financial services industry in relation to who's entitled to loans, etc., then you need to explain to the individuals in your privacy policy that that's what you do and the basis on which you make those decisions. And you also need to tell them that they have a right to have some human intervention in their decision if they wish. Where you're transferring data outside the EEA, you need to explain that. I think privacy policies currently do that. You need to explain what you're sending, where you're sending it, and why, and the sort of protections you have in place to ensure that the data is properly protected. So where you collect data from a third party, in other words, not from the individual themselves, you have to say where you're getting it from. So for example, if you're obtaining data from a business partner or from some aggregator or otherwise, you need to explain to individuals where that data is going to be coming from. As I mentioned, if you're sharing with third parties, you need to identify who they are and think about, are those entities data controllers or processors? So will they be processing the data in their own right for their own purposes, or are they just carrying out your instructions, in which case there'll be a processor? You don't necessarily need to identify them by name. We think that identifying by category may be good enough at the moment, provided that the data subjects have a good idea of where that data is going to be sent to. And again, as with all of this, it's important to take perhaps a risk-based approach here. So there's an obligation running through all this to be transparent, and the GDPR says that privacy policies, or the information you provide in privacy policies, should be concise, transparent, intelligible, and easily accessible. There is a sort of tension here because they're requiring, on the one hand, a lot more detail, but on the other hand, requiring it to be concise. So that presents a challenge in that we don't necessarily want to give users an incredibly long privacy policy, which, as we know, many people will never read. So the advice is really that this information should be displayed prominently on your website, for example, so not buried at the back of some terms and conditions, or not buried somewhere deep within the web pages. And to make sure that the average member of your intended audience can understand what you're saying. So there we're talking about clear and plain language, and if you have a particular audience such as children, then you should be using child-centric language, or if you're targeting non-English speaking countries, you should be providing translations, or if the English isn't going to be the first language of the audience, so for example foreign students coming into the UK, then you should be looking at using very simple language that can be readily understood. In terms of how to present the privacy policies, as I said, a very lengthy privacy policy document perhaps isn't the best way, and the ICO is encouraging organisations to choose a method that's appropriate to their circumstances. If you are giving the information online, you can use a layering technique where perhaps their main headings are given at first glance, and then users can click through if they want to find out more about, for example, retention of their data. They can click on that and get more detail. There are some other ideas that we've listed here in terms of, for example, pop-up notices, just-in-time notices. So as the individual is typing in their name and address, they might get a little notice that pops up and tells them how you're going to be using that. You can have a dashboard so that the individual can manage their privacy preferences all in one place. That might be something worth thinking about. And then it doesn't necessarily have to be written. So we've referred to the Internet of Things there, where clearly if you've got some sort of device, it might be difficult to give written information, but you could have a voice alert. I think really the point is to consider your particular context, consider the device which you're using in order to provide the information, and the user journey. So what will the individual experience as they go through perhaps the contract process or their relationship with your organisation. And one thing that's useful to do is to seek some feedback or possibly some testing before you launch it, so that you can allow some guinea pigs to try out your website and your privacy notices and feedback as to how easy or difficult or clear they found it. There is an exception in the GDPR if it's impossible to provide this information, but obviously that is going to be a pretty limited set of scenarios. There's no degrees of impossibility. So in almost all cases, it is going to be necessary to provide this information as clearly and as user-friendly as you can.
Thanks, Anna. So one of the other challenges that we're speaking to many clients about at the moment, and which is on the forefront of their minds, is how to deal with their existing marketing databases and how to implement GDPR compliant marketing practices going forward. So we thought we'd focus on this a little bit. Here, I think I need to talk to you a little bit about some forthcoming law in addition to the GDPR. So I'm not sure if you would be familiar with the current privacy and electronic communication regulations. So where we've mentioned on the slides PECR, that's what I mean, the privacy and electronic communication regulations. These form part of current law and they sit side by side with the Data Protection Act. And these laws are the laws which set out the rules on requiring opt-in consents for unsolicited email marketing, electronic marketing to individuals. And they also set out the rules on requirements for cookie consents. They work side by side with the Data Protection Act's overarching right that it grants to individuals to object to direct marketing. So the current position is that you consider the Data Protection Act and the PECR side by side. Now, in line with the GDPR, there is also a proposal to update these privacy regulations, and there is a draft e-privacy regulation which is currently in circulation. This is designed to work side by side with GDPR and the GDPR standards of consent and protections for individuals. So at the moment, it is not in final form. We expect it to be in final form either later this year or early next year. And one of the things that it will do is impact the way that businesses can carry out electronic marketing to other business email addresses. This is why it is being the subject of a lot of lobbying. So I'll have a look at how that is going to impact B2B marketing in a second. Just to also focus on some of the proposals within the e-privacy regulation, one of the other things that it is intending to do is to expand the scope of the prior consent that you need, not just to the sending of direct electronic marketing communications, but also to the presenting of direct marketing communications to end users. So this means that, for example, if you're going to be targeting the appearance of advertising to an individual, for example, a pop-up ad that is targeted to a user with your content based on some perhaps profiling that you've done on them behind the scenes, well, that's the sort of thing that is going to need to be the subject of an opt-in consent if the e-privacy regulations are implemented in the form that they're in now. So as I mentioned, under the e-privacy regulations, the plan will be to have express opt-in consent for the sending or presenting of electronic marketing, thinking about presenting and electronic marketing in these expanded concepts. There will still be a soft opt-in exemption that applies. So this is really to existing customers, and you can rely on this and send them marketing or present them marketing without having collected their express prior opt-in, if you have told them that that's what they're going to do and offer them the opportunity to opt out at the time when you're collecting that information. So in order to rely on this soft opt-in, you've got to be quite careful to meet those steps. If you are going to be wanting to rely on the soft opt-in for broader purposes, I think you need to proceed with caution. And in particular, with group companies, if marketing is going to be done, for example, on behalf of an overall brand, and perhaps directly by other companies within a brand, then it's likely that you won't be able to rely on the soft opt-in and you'll have to get opt-in consent. And when we talk about consent in this context, we're talking about consent in the GDPR standard. So under the GDPR, consent has got some very specific requirements. Consent needs to be freely given, specific, informed, unambiguous, and it's got to involve the individual actually doing something. And when the consent is given, it must be given on a transparent basis. There's quite a bit of guidance on what the GDPR, what the regulators mean by consent. And if you are concerned at all, it's worth having a look at that guidance. One of the important things also is the specific requirement under the GDPR to demonstrate consent. So how can you verify the consents that you are relying on? So those are that's the legal framework that's relevant under the GDPR in this context. Now we look at it in relation to B2C marketing and then B2B marketing. So business to consumers first. So if you are carrying out marketing to consumers, and you're carrying out electronic marketing to consumers, chances are that you will already have some opt-in consents under the PECR, which you will need to have a look at to see if they are sufficient in the GDPR and anticipated e-privacy regulations world. So you're going to be looking at it from the perspective of, can I still rely on the consents I've got? And what do I do going forward in terms of the new consents that I'm capturing? With the new consents that you're capturing, I think that's obviously an easier thing to do. You can sort of future-proof them by expanding the language that you use in relation to consent capture to make sure that it's transparent, to particularly highlight any things that involve personalized forms of marketing and the presenting of advertising to individuals. And if you have a look at the consents that are being used in cookie banners, for example, or opt-in, consents in the likes of, I've seen it on Tesco, House of Fraser, a number of different retailers have already started to do this in terms of their consent captures. So that's something that is worth looking at for your B2C consents now, which will hopefully put you in good stead when the e-privacy regulations are implemented. Then you have to look at your current consents and think, can I still rely on them in the GDPR world? So firstly, the scope of the consent. Is it wide enough to capture what I am currently doing? Was it clear enough when I asked for this consent for the user to transparently understand what I meant by, what I'm going to be doing with this data? Am I using am I carrying out personalized marketing, and does the user know this? These are the sorts of things that you need to think about when you're checking whether or not your consent is sufficient. And if you're relying on the soft opt-in, how can you demonstrate that this is valid? Did you give the individuals an opportunity to refuse marketing at the point of collection? Can you demonstrate that you did? So some analysis on the current consents is also required. Looking now at B2B, and as I mentioned, the draft e-privacy regulation does represent a big change. We know that it's in draft form, but we think it is unlikely to change in this regard, despite the lobbying, because of the position that the regulators seem to be adopting. So the UK Information Commissioner, Elizabeth Denham, recently spoke to the Direct Marketing Association, and the text of her speech is available on the ICO website in case you're interested. But the message is very clear that even though businesses will find getting prior opt-in consent a real challenge when marketing to cold contacts for electronic marketing, this seems to be the expectation. They want businesses to think about how to engage and obtain consent so that they can be marketing to individuals who genuinely want to receive it. So the proposal is that all natural persons to whom electronic marketing is sent or presented will need to have given their prior opt-in subject to the soft opt-in requirements. So this means that if you are emailing somebody at their business address, such as the one on the website, you will need to comply with those consent requirements. If you are sending it to a non-natural person, for example, info@penningtons.co.uk, then those opt-in rules don't apply. So again, with B2B marketing, you're going to need to check to what extent do I currently have consents, and how do I implement something which is going to put me in good stead for the future should the e-privacy regulation be implemented in the form that it's in now. So you'll look at your database and have and assess the information that is held within it. And with this assessment, you're also going to be thinking about the GDPR principles of data minimization, not holding data unless you need it or have a basis for keeping it, and your legitimate interest in holding this information. So if somebody has been receiving marketing emails from you in a business-to-business context for a long time, and you can see that they've never opened it, can you really say that you should be continuing to send them information? Perhaps you should be taking the decision to delete those contacts. And similarly, with individuals, you may, if you have opt-in from an individual in the B2C context, have you refreshed your consent from them? And if you haven't, and again, you can see that the individual isn't opening your emails or has deleted them immediately, perhaps think about whether or not you need to retain them. Reconsenting or programs to request consent, you will see that many organizations are currently going through this, and you may well be thinking of running such a program yourself. For B2B marketing, I think probably it is a good idea to start collecting consents in anticipation of the e-privacy regulation. You need to think about how you will do that and build a database that is robust. In the B2C context, this is something that requires caution. If you recall, we need consents to be demonstrable and verifiable. And in this context, I'd like to just mention the ICO recent regulatory action in relation to Honda. So here, Honda sent marketing emails to individuals asking, would you like to hear from us? Where the individuals they thought had consented, but they could not demonstrate within their CRM system that a consent had been obtained. And this activity was deemed to be an unsolicited marketing activity in itself, which triggered a fine. So that's an overview, really, of quite a complex topic on marketing. We're now going to move on to data breaches, and I'll hand over to Anna.
Thanks, Joanne. So with the best will in the world, even if you've put all these steps in place in terms of policies and procedures and training, from time to time, in the best run organisations, data breaches will occur. We've put on this side some analysis of the types of breaches that were reported to the ICO during the last year. And as you'd expect, the vast majority is caused by human error and the kind of things that we might read about in the press from time to time, such as loss of paperwork, data that's posted to the wrong recipient or emailed to the wrong person, people who fail to use BCC and therefore disclose all the recipients of an email, people who lose laptops, etc., and paperwork that's just dumped in a black bin bag outside the office door. So these are frequent occurrences. They can amount to data breaches if the data includes personal data, and so we need to look at how we go about preventing them. Also listed, the second block on there is cyber incidents, and I think we're all aware through the media of increasing incidents of hacking, etc., and that's also something that organisations should be seeking to minimise the risk of. So if we turn now to the measures that your organisation might consider putting in place, the GDPR recognises that organisations need to weigh up really the state, various factors in deciding what's appropriate for them. So you can take account of the state of technological development in terms of what recent software packages are available to you and updates, the cost of implementing these measures weighed against the potential harm and taking into account always the nature of the data. So where it's a very large blue chip company, then they might be expected to take greater measures than an SME, for example. And where an organisation is dealing with sensitive or special category data, then they would need to take additional security measures. It's important to remember that it's not just an IT issue. So while you wouldn't be needing to talk to your IT team or your external IT provider about suitable protections, and those might include, for example, firewalls, most up-to-date software, perhaps removing unused software which could provide a way into the organization's systems, having clear policies on usernames, passwords and permissions, encryption, antivirus software. There are all these things that your IT people will be aware of and can update you on in terms of what you have already and perhaps what could be improved. But in addition to that, it's important not to forget the more physical aspects of data security, such as, for example, access to your premises. So are there good controls over access to your offices, and are visitors supervised, for example? Is your paperwork stored securely? Are laptops and other devices locked at night if they're left on the premises? And what happens to waste paper? Is it shredded securely, etc.? And again, training is an important part of all of this, so that your staff know how to look after their mobiles, laptops and other devices, how to recognise phishing attacks, etc., if they come across them. Where you're using processors, you need to expand your review to them as well. So when appointing a processor, it's important to do some due diligence as to the sort of security they can provide, and can they guarantee that to you. Also to place it into the contracts that you have with them. So put those obligations about security into your contracts with your processors. We'll come on to that in a bit more detail later, and then ensure that they are actually doing what they have promised to do. But as they always balancing the risk against the availability and the cost to your organisation of these measures, and doing what's proportionate. So on the next slide, we have some actions that you might start thinking about now, including implementing a cybersecurity policy, which is something you can do in conjunction with your IT experts. Then communicating that policy to staff, and as I say, providing training so that they know how to report incidents if and when they occur. And this is very important now under the GDPR, because the time frame, well, first of all, it's become much more mandatory to report data breaches, except in certain circumstances, and also the time frame for doing so is shorter. It's now 72 hours unless you actually can't do it within that time frame. So it's important to react quickly, and therefore your staff and processors will be key in alerting you as soon as possible. In addition to having the policy, then it's useful to have a response plan, so that, as I say, you can react quickly and people know what to do and when. And of course, part of it, very much so, is looking at the security systems you have in place to make sure that they're adequate and up to date. Going back to the data sharing, where you've got processors or you're sharing with other entities, then, as I said, looking at their security, putting a breach or reporting obligation onto them with a time frame, and then requiring the processor to assist you in managing any data breaches that might occur. So not only telling you it's happened, but providing you with the sort of information you will need to report on to the regulator, such as what kind of data was lost or leaked, and how many individuals did that affect, and what's the likely impact, and what steps are being taken to mitigate that damage, and also to prevent it happening in the future. So these are all things that you can be thinking about now and trying to put into place. We're conscious that as a law firm, that going forward there is likely to be an increase in individual claims for data breaches. Partly that's because of an increased awareness generally from the public around data, the importance of data protection and their own rights, and also the change through the GDPR, which sets out very clearly the enhanced rights that Joanne's going to talk about shortly. I think just through media coverage such as Facebook, Cambridge Analytica, etc., people are just becoming much more alert and alive to their rights, and also to possibly bringing claims if those rights are infringed. The case of Vidal Hall established that individuals can bring claims in respect of distress only, so they don't need to have lost any money, for example, through the breach. And in the case of Morrison's, in which an aggrieved employee uploaded an incredible amount of data to the dark web and ended up in prison for doing that, Morrison's was held vicariously liable for his actions just by virtue of him being on their staff. They're appealing that, but potentially the number of claims they could receive would be large. We also think there may be a prospect of class actions for data breach in a situation like the Morrison's one, where there's a big cohort of individuals affected. So this is just by way of being aware that data breaches may become much more of an issue for organisations. So I will hand over now back to Joanne, who's going to talk about these enhanced rights in more detail.
Thank you, Anna. So individuals, of course, do have rights under the Data Protection Act at the moment, and what the GDPR does is builds on those. So existing rights, for example, like the right of access to data, has been continued under the GDPR in a way which shortens the time frame for response. You need to respond within a month rather than 40 days, removes the ability for organizations to charge, except in very limited circumstances, for actual costs. So there are some changes to individuals' rights and new rights, which I've mentioned on the slide. And wherever you are interacting with data subjects, whether it is in the context of them being your staff, in the context of recruitment, or in the context of your customers or prospective customers, you need to be thinking, well, how do I communicate to the individuals that they have these rights? Because that is something that you have an obligation to do. So firstly, the right to, how do I satisfy the right to inform individuals about all of these rights in the first place, and also how will they know how to implement the rights should they wish to do so. So looking at it in the context of communication is one thing, but then also in the context of implementing these rights. So for all of these rights, we've got relatively short amount of time to actually comply or to satisfy the individual's requests when they are made. So we need to think about that in the context of the data that we hold, and perhaps thinking about how to streamline the processes for particularly important data sets. So for example, if you're a university and you are processing data of students, which is affected by the right to data portability, which is an entirely new right. That is a right that applies when you're processing data on the basis of either consent or a contract. And it requires you to provide that data to the individuals upon their request in a format which is easy for them to use if they want to move to another institution or service provider. So you need to think about, firstly, does this apply to me? And secondly, how am I going to address it? And the regulator's guidance has recommended thinking about things like self-service portals, for example, where individuals can download their the data that is captured, those sorts of things. So in terms of implementing processes to comply with the data subject's rights, you'll need to be thinking about what processes can I implement? Can I do more than just communicate them to individuals at the moment? Can I actually look at my systems, tag information that I think might need to be forgotten for client data requests, for example? How am I able to comply with the circumstances where I've disclosed data to third parties and I may need to onward communicate the right to be forgotten to those people? Can I easily see that information from my systems or my data map? These are the sorts of things that you will need to think about in a practical way to help you comply with the individual's rights as and when they may be exercised.
Thanks, Joanne. So coming back to looking at data sharing in a bit more detail, we mentioned earlier the need to have a contract with your data processors, and you might have data processors for a number of different purposes. For example, your payroll provider or a marketing organization that sends out mail shots on your behalf, for example, IT providers externally. It's required under the GDPR to have a contract with those processors. You may already have one, but if you do, it probably needs looking at and in many cases adding to, because the GDPR sets out in very clear terms what you need to be covering in those contracts. And some of them are listed here in terms of the subject matter, the nature and purpose of the processing that entity is doing for you, the type of personal data they'll be holding, how long they'll be holding it for, etc. So we've listed those out in a bit more detail on the next slide, and these are the kind of things that you will be needing to cover in your contracts to do with, for example, the obligation of confidentiality, security that the process is required to ensure, the fact that if they want to subcontract to use a sub-processor, that they will need the controller's consent to that, that they will assist the controller if the data subject exercises one of the rights that Joanne mentioned, for example, subject access request, then you will need possibly the processor to assist you in responding to that, to tell the controller where there's a breach situation, and then at the end of the arrangement to either delete or return the data to the controller. And running through all that is requiring them to be able to demonstrate their compliance with the agreement, perhaps allowing you to audit them and inspect them. So in terms of practical steps, probably the first thing to do is consider what your existing arrangements are with any of these third parties. So consider are you sharing data with anyone, and if so, are they a data controller? In other words, they're processing the data on their own account for their own purposes, or are they a data processor where they're carrying out your instructions? And if they're a data processor, are there any sub-processors involved? So first of all, analyze all of that, and then consider what documentation you might need to improve your compliance. So in terms of the outward facing to the data subjects, in your privacy policy, you'll need a clear statement, as I mentioned before, about who you're sharing data with, either by name or by category, and then set out in that what's the legal basis for that sharing. And you'll need to analyze that. Why are we sharing this data, and what legal basis do we have for doing that? It might be that it's necessary for the contract. It might be that you have a legitimate interest. It might be to comply with the law, for example. There are various different grounds on which you might be sharing that data. And then in your data sharing agreement, you need to set out each party's responsibilities. And those include the ones that we just ran through. So look at your contracts that you've got in place now, see where they need to be added to, put in place perhaps some improved templates that you can use going forward, and think about how you select your processors and the sub-processors. So those are the practical things that we recommend there. I'll hand back over to Joanne now to talk about data protection officers.
Thanks, Anna. So the GDPR, as you probably know, has a requirement for organizations, controllers and processors, if they meet the criteria set out in the GDPR, to appoint a data protection officer. And those are set out there on the slide. If you don't meet the criteria, you may choose to appoint a data protection officer on a voluntary basis. But if you do so, and you call that person a data protection officer, then they need to be treated in the way that the GDPR mandates. So have you gone through that assessment process to decide, firstly, do I need a data protection officer? If yes, then you're going to have to ensure that such a person is in place in a way which meets the GDPR requirements. If no, you're going to be thinking about, do I want to appoint a data protection officer on a voluntary basis? And if so, am I going to be comfortable that this data protection officer my organization is capable of treating that person in the way which is required under the GDPR. And if you don't fall within either of those categories, you'll be thinking, well, so who within my organization is going to be responsible for overseeing data protection compliance? Now, as we all know, and we haven't mentioned it too much here, the repercussions for data protection breaches are significant, and the implications of compliance are quite wide-ranging throughout a business. So it's not going to be something that just impacts, you know, the IT department or the finance department or the HR department or the customer relations department. There should be somebody with oversight of all data protection activities to promote the organization's compliance generally, and in particular to encourage things like privacy by design as part of your business. So how is your business going to tackle that? I guess one of the considerations that many businesses are thinking about at the moment is if I need to appoint a data protection officer, can I appoint one externally? And there are a number of services that are being offered by companies, compliance-facing organizations, which enable you to have like a data protection officer as a service on a subscription type of basis, and that might be an entirely appropriate thing for you to want to do. You just need to make sure that you are buying in, if you take that approach, buying in the right level of support that your business really needs in order to comply.
Thank you, Joanne. So lastly, we'll just cover record keeping, which is another obligation under the GDPR, which is probably new to a lot of organisations. So there's a requirement. Well, I'll look first at controllers and then at processors separately, but controllers are required to keep records of the things that we've listed here, some basic things about the name and contact details, but also the purposes of the processing, the categories of the data subjects, in other words, the individuals and the type of data that's being processed, where they're sharing or who they're sharing data with, if they're transferring it to a third country, and on retention and erasure, and also descriptions of the security measures. This is an internal record keeping exercise, so this is separate from what you might put in your privacy policy, but it's something for you to have internally and obviously to update and refresh as time goes on. Turning now to processors, they currently under the Data Protection Act have many fewer obligations, but they will also have this obligation under the GDPR among their other obligations to keep records, including the details of the controllers on it, who they're working for, and the types of processing they're doing, and then details about international transfers and security measures that they have in place. We have included on this next slide details of the ICO website, which is a good source of guidance on many of these topics. So if you go to the website and look in the section for organisations, there's a whole list of guidance, and you can get much more detail from that if you want on lots of the things that we've talked about today, as well as getting ready for the GDPR, and they have helpful 12-step tips and so forth on there. Lastly, just before we move on to questions, I just wanted to mention that at Pennington's Manchester we've developed a GDPR readiness service, which is a fixed price package for organisations, particularly SMEs, to enable them to help achieve their compliance. And that package comes in two stages, so that we can help you with the data mapping at the outset, and then if you identify any gaps or any documentation that you need help with, then we can provide sort of optional modules depending on what you might need in terms of documentation or further advice. And that's provided by our data protection team, of which Joanne and I are members. So I'll hand back over now to Katie, who is going to look at the questions we've received.
Yes, we've received lots of questions, so we'll try and get through as many as we can. So just to kick off with a question for you, Joanne, to start, it's with regard to consent for electronic direct marketing. So what if people are emailed regarding opting consent and they don't respond? And also, as verbal consent is not necessarily documented, does that mean it's not enough under the new GDPR guidelines?
Okay, thanks for those questions. So in relation to the first one, so you've emailed someone requesting consent and they haven't responded. So I think that if they haven't responded, you've got to think, am I entitled to send them a reminder or not? If they are a business-to-business contact, then you could possibly send them a reminder before the e-privacy regulations come into play, but you shouldn't send them too many. And if they still don't respond, then you ought to delete the contact or at least cease marketing to that contact and check that you have another reason for keeping that contact information if you do so. In relation to a consumer contact, I would delete the contact. I wouldn't ask again. Just ask once for consent, and then unfortunately, if they don't respond positively, delete the contact or cease marketing to that contact. In relation to verbal consent, this is an interesting one because I think that verbal consent can be valid consent for GDPR purposes. And in fact, this is reflected in some of the guidance that we've got on consent. It's just about the steps that you take to document that. So actually, we've gone through this process of helping a client in the retail context rely on verbal consent. And there, while we recognize that this might not be as easy to demonstrate as a written consent or consent given online, you have to show that staff follow a particular script in relation to the asking of consent, and they only record that consent on the system when the customer has given a positive action. So the customer has to say yes, the customer can't be silent, and the staff has to know that in order to say, okay, I'm now going to record your consent. So that's the first stage of collecting that verbal consent, and you document that by the script that you have together with the training materials that you give to that staff. And then your consent on the system can then record the time and date in which that happened. So that recording onto the system has got to got to occur pretty quickly. And then you follow up after that with all the fair processing information that you need to give.
Great, thank you, Joanne. Are there any exemptions for small charities or membership organisations? So thinking particularly of organisations where there's a movable membership, or so for example a church, or where there's people have opted in to join, such as a livery company.
Well, we're unsure at the moment because in the Data Protection Bill, there is some reference to churches and religious associations. I can't remember exactly how they might be able to rely on public interest type exemptions or public interest type processing categories. I think because it's quite a specific type of question relating to that organization, we'd have to look at how they fit into the public interest sections. But there is no blanket exemption for the GDPR for those types of organizations. They may just have to they have the ability to rely on different types of legal bases for processing.
Thank you. And we've had quite a few, just another question to follow on again on the direct marketing. For direct marketing that requires opt-in, does that mean that you can't send information to people on LinkedIn, so those sort of social media sites?
Yes, LinkedIn is an interesting one because there's also the membership rules of LinkedIn itself, and those of us who are members of LinkedIn will no doubt have seen that they seem to be quite regularly updating their terms of service to ensure that we transparently know that when we sign up to LinkedIn, we're accepting certain features of it, such as the ability to communicate. So I think that with LinkedIn, you're just going to have to comply with the LinkedIn rules, but also I think that you need to be careful there because just because somebody has a LinkedIn, if they're not connected with you, if they are just a person that you are aware of on LinkedIn and you're contacting them through that platform to send them marketing material, that is also likely to be caught as unsolicited marketing. I would request the connection first, and then have a more personalized approach, probably.
Okay, Thank you. And I think we've probably got time for one more question for you, Anna. With regard to existing contracts with data processors that are non-GDPR compliant, is there a quick fix that we can put in place without reopening those contractual negotiations?
In many cases, it won't be appropriate to reopen the contract, and so what we are suggesting that our clients do is to put in place a side agreement or an addendum, which follows on from your original contract, but deals purely with these GDPR requirements. So yes, you don't need to reopen the whole contract you had before. You just need to put in place a follow-on addendum, really, that deals with that. Great,
thank you. I think we do have time for another question. I think if I could ask one. So one question we've had is looking at where we've got data share in terms of the data protection officer. So does the DPO have ultimate responsibility for compliance for the whole organisation if you've appointed one?
No, so the data protection officer is most certainly not personally responsible. Those of you who are data protection officers would be pleased to hear that. The obligations are very squarely placed on the controllers and the processors, and they are the ones that have the duty to equip the data protection officer with the resources they need to follow the tasks, involve the data protection officer on all aspects that have a privacy issue, and to take into account the data protection officer's recommendations, which should be given on an independent basis. And also just worth mentioning that if an organization decides not to follow the recommendations of a data protection officer, then that ought to be documented, and the reasons for that ought to be documented as well.
Great, thank you, Joanne. I think, unfortunately, that means that we are almost out of time. Sorry if we haven't had time to answer your questions today. If you do have any more or further or specific questions that you'd like to follow up, please do feel free to contact Joanne or Anna. And really, it just leaves me to say thank you to Joanne and Anna for your talks. They were great. And thank you all for listening in. Goodbye.